What are intervention proceedings? Intervention proceedings are also known as adult guardianships and conservatorships. They are for adults who cannot make decisions for themselves and own assets or have money that needs overseeing. D.C. law requires the guardianship or conservatorship least restrict personal freedoms while also providing protection. There are some less restrictive alternatives to a full guardianship. These should be considered first and include things like supported decision-making, which may include a power of attorney or a representative payee.
Two kinds of people can be appointed to help an incapacitated adult with decision-making: guardians and conservators. A guardian is appointed to make decisions about a ward's physical well-being. This includes decisions such as medical treatment, medications, food, doctor selection and appointments, and where the ward will live. For instance, assisted living or another living arrangement. A conservator is appointed to make decisions about assets, property, or finances. When appointed, a conservator may require insurance to help protect a ward's assets. Examples of assets include bank accounts, land, or other property. The conservator must also be aware of obligations such as taxes or other bills. Guardians and conservators don't settle disputes, and they don't get custody of the adult. A guardian gets to decide about the physical person, while a conservator reviews the person's assets and oversees them, making decisions on how best to administer those assets. Overseeing bank accounts and finding any outstanding debts is also part of this process.
How are guardians and conservators appointed? File a petition for general proceeding when concerns exist about an adult's ability to decide for themselves. The petitioner will be responsible for having a copy of the paperwork delivered to the other side. This is called serving the other party. Even if the petitioner lives with a potential ward, they must have the papers delivered by someone over the age of 18 who is not involved in the case. The petitioner is responsible for proving that the person in question is, in fact, incapacitated. There is a legal difference between incapacity and incompetence. You can read more about the difference through a link at the end of this video. To prove that a person is incapacitated, the petitioner should send medical evidence with the petition or request that the court appoint an examiner to help evaluate the person in question. Medical evidence includes evaluations from medical doctors and psychiatrists. A trial or hearing may be scheduled for the petitioner to present evidence. This will also be an opportunity for the subject of the petition to respond. A lawyer will be appointed to represent the person's wishes. If the subject cannot engage or communicate, a guardian ad litem may be appointed to represent the person's best interests.
As approved by the court, people involved in intervention proceedings, such as attorneys, examiners, guardians, and conservators, are entitled to compensation for services rendered. They are also entitled to expense reimbursement. At the trial or hearing, the judge will determine whether a guardian or conservator should be appointed. Their powers may be limited or substantial, depending upon the needs of the incapacitated person. Even if you file a successful petition, that does not guarantee that you will be appointed as a conservator or guardian. The court will decide what's best for the ward. Temporary guardianships can be put in place for 21 or 90 days in emergency medical situations when no power of attorney or family member is available to make decisions. A general or permanent guardian has full powers to decide for an incapacitated adult until the adult dies, or the guardian resigns or is removed by the court. A limited or temporary guardian is only allowed decision-making powers on a specific healthcare issue as directed by the court during their appointment.
The Probate Division has a self-help center to provide information on forms and how to get started. You should also visit the court's Forms Help online portal for assistance. Live chat is also available on the Probate Self-Help Center website during regular business hours.